Hello everyone and welcome to LiveLaw. I am Advocate Anna Oman. These days you might be reading a lot about the CAA or the Citizenship Amendment Act. Today I will be talking about the legal aspects behind this controversy. What are the laws dealing with this? Let us examine. The first one is our own supreme book, the Constitution of India. Article 5 to Article 11 under Part 2 of the Constitution deals with citizenship and empowers the Parliament to make law to provide for such matters and any other matter relating to citizenship. The second one is the Act, which is the Citizenship Act 1955. Like most of the acts, this act has been amended many times in the year 1986, 1992, 2003, 2005, 2015 and 2019. In India, there are 4 ways to get citizenship as per the Citizenship Act 1955. Section 3 talks about citizenship by birth, Section 4, citizenship by descent, Section 5, citizenship by registration, and Section 6, citizenship by naturalization. The controversial amendment which is being talked about now came in December 2019. Before going into the 2019 amendment, let us quickly run through the amendments from 1955 to 2019. As per the original Section 3 of the Citizenship Act 1955, individuals born in India on or after January 26, 1950 can acquire Indian citizenship if either of their parents is a citizen at the time of birth. Let me try to explain this in a simple manner. Imagine a small family, Ramu and Geeta. Ramu is an Indian citizen. Geeta illegally entered India without valid documents. Ramu and Geeta both got married and they have a daughter named Tina. Now their daughter Tina will get Indian citizenship since Ramu, her father, is an Indian citizen. This was the situation in 1955. Now let's see what happens as per the 1986 amendment. There was an amendment to Section 3 in 1986. As per the 1986 amendment to Section 3, that is the first amendment, those who are born in India on or after January 26, 1950 but before July 1, 1987 shall be Indian citizen, but it was no longer needed to be born in India to be granted Indian citizenship. At the time of birth, either one of the parents has to be an Indian citizen for the individual to become a citizen of India. So now, Tina's mother was not an Indian citizen, but Tina's father was an Indian citizen. Tina was born in the US and she would get Indian citizenship since her father is an Indian citizen. Now let's see how the situation changes after the 1992 amendment. The 1992 amendment amends Section 4 of the Citizenship Act 1955, which is citizenship by descent. Section 4 says that any person born outside India is considered a citizen of India by virtue of citizenship by descent if either of the parents were a citizen at the time of his birth. By way of this amendment, the gender discrimination in the Act was removed. Earlier, as per the 1955 Act, only father's citizenship was considered. But by this amendment, if either of the parents, that is mother or father, can be a citizen by descent, and if they were a citizen by descent, then their children will also get the citizenship. So, if Tina is born in the US, but mother was a citizen by descent, then Tina is entitled for citizenship by descent. But there are certain other conditions to be met, that the birth should be registered at an Indian consulate within 1 year. By the 2003 amendment to the Act, many changes were brought. 1. It allowed the Government of India to build a national register of citizens. 2. It introduced the term illegal migrant. As per 2003 amendment, an illegal migrant is a person who enters India without valid travel documents like passport or visa, or overstaying in India beyond the permitted period. Illegal migrants were not allowed to get citizenship by registration or naturalization. Also, if the children are born after 2004 and one of the parent is an illegal migrant, he is not entitled for citizenship. The 2003 amendment also introduced the concept of OCI, that is the Overseas Citizen of India. That means if person is of Indian origin, they can visit India without a visa. Another most important aspect is the introduction of National Register of Indian Citizen, which permitted the government to compulsorily register all Indian citizens and issue them identity cards. NRC was only implemented in the state of Assam under the direction of the Supreme Court. Let us examine how 2003 amendment is going to affect Ramu and Geeta's family. So now, Ramu and Geeta gave birth to a second child named Krishna in the year 2005. Their son Krishna is not qualified to be an Indian citizen since Geeta has now, as per the 2003 amendment, become an illegal migrant. The Citizenship Amendment Act of 2005 introduced a dual citizenship system allowing individuals from 16 countries other than Pakistan and Bangladesh to obtain dual citizenship. The 2015 amendment modified the provisions which pertain to the Overseas Citizen of India, that is the OCI. It introduced a new scheme called the Overseas Citizen of India card holder by merging persons of Indian origin and the OCI card scheme. The amendment stipulates that when an individual renounces their overseas citizenship, their minor child automatically loses their status as an overseas citizen of India. Now, according to the 2019 amendment, Section 2, Subsection 1, Clause B states that any person belonging to the Hindu, Sikh, Buddhist, Jain, Parsi or Christian community from Afghanistan, Bangladesh or Pakistan who entered India before December 31, 2014 without valid documents will not be treated as an illegal migrant. It exempts the members of the 6 communities from any criminal case under the Foreigners Act of 1946 and the Passport Act of 1920 and shall not be treated as illegal immigrants if they entered India before December 31, 2014. As per the 2019 amendment, the amendment excludes Muslims, or in other words, this amendment for the first time has been given a color of religion. The 2019 Amendment Act separates refugees and asylum seekers in India based on 2 factors. One is where they are from, Pakistan, Afghanistan and Bangladesh, and 2, their religion, Hindu, Sikh, Buddhist, Jain, Parsi or Christian. People in these groups are not treated as illegal migrants and are placed on a fast track to citizenship. So the primary criticism against the act is whether a secular country like India, which has no official religion, can exclude a particular religion on basis of citizenship. We all know that Pakistan is an Islamic country by its constitution. Afghanistan is also an Islamic country by its law. Similarly, Bangladesh is also an Islamic country. The CAA has excluded Rohingyas in Myanmar, Ahmadis and Shias in Pakistan, Muslims and Tamils in Sri Lanka, and other persecuted religious minorities from the treatment which is extended to Hindu, Sikh, Buddhist, Jain, Parsi and Christian communities. If the migrant is not amongst the 6 religions, they would not qualify for protection under the Amendment Act, even if they have faced religious persecution. So far as India is concerned, we do not have an official religion. The 2019 amendment says that only some people belonging to certain religions can acquire citizenship. So indirectly, it is just Muslim people who are not allowed citizenship even when India is neither a Hindu country nor a Muslim country as per our constitution. Around 237 petitions are filed before the Supreme Court by the state of Kerala, the Indian Union Muslim League, Democratic Youth Federation of India, Congress leader Jairam Ramesh, Trinamool leader Mahua Moitra, AIMIM leader Asaduddin Owaisi, All Assam Students Union and others. Coming to the issue faced by the northeastern states, there exists a different problem altogether. For example, Assam being a border state, specifically after the 1971 war with Bangladesh, lot of people came to India as refugees. The issue concerning the people of Assam is not rooted in religious aspects, but rather in the segregation of outsiders who arrived after 1971 and that it particularly affects indigenous culture. In the case of Tripura, the people who came from Bangladesh were almost equal or more than the local population. So, Tripura, otherwise a tribal state, as majority of the population was tribal and the local people became the minority. They are also opposing the Citizenship Amendment Act. The agreement called the Assam Accord 1985 promised to find and send back any people from other countries who came into Assam after March 24, 1971. But the present Citizenship Amendment has made the cutoff date as 2014, which means that thousands of non-Muslim foreign nationals will be legally allowed to settle in the state. Let me explain the nature of CAA with an interesting case from the Supreme Court. In 2022, a habeas corpus petition was filed seeking release of Mohammad Qamar, a 62-year-old man who was under detention in foreigners' detention camps since 2015. Mohammad was alleged to be a Pakistani national, and his children filed the petition stating that their father was born in India in 1959 and had gone from India to Pakistan along with his mother in 1967 on a visa to meet his relatives in Pakistan. Mohammad remained in Pakistan under the care of his relatives after his mother passed away. Around 1989-1990, Mohammad returned to India and married an Indian citizen in Meerut, and 5 children were born in India who have Indian citizenship. Then, in the year 2011, police arrested him, accusing him of being an illegal migrant, and a case under the Foreigners Act 1946 was filed against him. The trial court found him guilty of the offence under Section 14 of the Foreigners Act 1946 and sentenced him to 3 months imprisonment. The allegation against him was that he was residing in India after the expiry of his visa. Then in February 2015, he completed the sentence. Though he completed the sentence, his status was that of an illegal migrant, and he was put inside detention center and he remained there for 7 years. His children filed a habeas corpus petition seeking his release, and Supreme Court directed his release. Now this is something to ponder upon. If Mohammad Qamar had been a non-Muslim, he would have got the benefit of the Citizenship Amendment Act 2019. So had he been a non-Muslim, he would have ceased to be an illegal migrant because of the proviso added to the Section 2, subsection 1, clause B of the Citizenship Act by the CAA. So what exactly is the basis of this amendment? Is it purely on the basis of human rights? Because there are Muslim refugees, Rohingya refugees who allege that they are being persecuted and are seeking asylum or citizenship in India. Can they be discriminated because they are Muslims? These are broader issues being considered by the Supreme Court, and the matters are set for hearing on 9th April 2024. Thank you for watching. I hope you liked this video and found it informative. Do let us know about your views in the comment section below. Do not forget to like, share and subscribe to our YouTube channel. Stay tuned for more such content.